everyone, welcome back to Move with Martin, where we explore the real side of real estate, life, and everything in between. Today we're diving into a topic that a lot of folks don't think about until they have to, and that's probate and how it can affect real estate. Joining me today is Wayne Bailey from Green Country Law Group, located right here in Tahlequah. We're going to break this down in plain English so you walk away a little more prepared in case you ever have to deal with this. Let's start from the top. What exactly is probate and when does it come into play?
Well, probate, at least in Oklahoma, of course, I want to make sure everyone understands all my answers are related to Oklahoma law only. But in Oklahoma, it's a court-supervised process of distributing a deceased person's assets. It comes into play when you have assets that are owned by a decedent that don't pass by operation of law. In other words, you know about a joint tenancy bank account, those kind of things. Those don't require probate, but if you don't have joint tenancy or some other type of joint ownership, it requires probate for assets over $50,000 in cumulative value.
And why is it even necessary in the first place?
Well, there's just some assets that you can't title in someone else's name unless you go through the process. It's to make sure that that the persons that should end up with ownership of the property end up with the ownership. It prevents, like if you got multiple children, it prevents one child from coming in and taking the entire inheritance instead of making sure it goes the way it should. And that's determined either by the decedent or the law. And I'll leave that to, looks like you've got another question. I'll address that.
What happens to someone's home when they pass away without a will?
Well, without a will is known as an intestate estate. So literally that means without a will. And the laws of Oklahoma provide for what's called the descent and distribution of assets based on heirship. So the law looks at who the decedent is. It looks for surviving spouse, children, parents, and so forth, and determines who the heirs are based on that legal analysis. And then the property is passed to those heirs in the probate process.
What if they do have a will? Does that skip probate?
It does not. Any property that still is subject to will has to go through probate. Same process, just a few more formalities, and those formalities are to make sure that the will is actually valid.
And how long does the process typically take?
We tell our clients that a fast probate is 9 months, and there's so many variables involved. I mean, you can have them done quicker than that. It's unusual because of holidays, court dockets, things like that. But it's not unusual for a probate to last 12 to 18 months. Even standard probates that just have the nuances, taxes, creditors, those kind of things.
Now let's talk about what happens when there is a house involved, which is often the case. Can the heirs sell the home during probate?
They can, as long as there's not if it's a will, and the will says the house goes to a specific person, you can't necessarily sell it inside the probate unless there's no other assets to sell. If the home is to go to all the heirs equally, and if all the heirs agree, then they can sell it inside the probate. And the next step would be that if that's the only asset and there's expenses from the decedent, funeral bills, creditors such as that, then the home can be sold by basically a court process. So the answer is yes, and it's actually easier to sell during probate than it is to do so afterwards.
Now, what if one person wanted to sell but the others don't?
Kind of goes back to the answer I just gave on the first step, and what that means is the person or persons that are appointed personal representative or administrator or executor, they're charged with the duty to make sure that the decedent's debts, taxes, and wishes are followed to the best extent that they can. So if the decedent left, for instance, in this scenario, left just a house, but they left some credit card debts and unpaid taxes, and the property was intended to go among the decedent's children, and if one didn't want to sell it, the only way they could avoid that is if that child bought the home in order to provide money to the estate to pay those debts and taxes.
Gotcha. Can someone live in the home while it's going through probate?
They can, and the problem with that is, I say a problem, and the process is, the problem is if the executor lets someone live in the home without charging rent, then that executor could be liable to the other heirs for the fair market value of rent that they didn't collect to the estate. So traditionally what you do is if you have someone who wants to live in property, you just obtain from someone such as yourself, a realtor might know what the fair market value of rent would be for a property like that, and you have them pay that fair market value of rent into the estate. And if the person in the home is an heir, they'll get their proportionate share of it back at the end.
What kind of legal roadblocks do families run into with inherited properties?
Legal roadblocks. There's not really a legal roadblock when it comes to inherited property, as long as there's ownership in the decedent. So, I guess that might be a problem, is if the title itself is not good in the property that the decedent owned. More often than not, though, you'll see liens that they might have planned on, tax liens or other liens that the heirs might not have known were out there that'll have to be satisfied before the property can be inherited.
For folks listening who want to avoid putting their family through a probate mess, what should they do right now?
Well, the only way to avoid a probate is to either own assets or take care of it through a probate substitute process, which is most commonly a trust. And I know we're going to talk about that later. So to the extent, I'll wait and let you ask whatever questions you want. But that's the only, well, if you own property that could require a probate, that's the only way you're going to get there. 1 square inch of land requires a probate.
What's the role of a living trust, and how does all that work?
Well, a living trust, a lot of people confuse what the living part means. It literally means a trust that you created during your life. The fancy term is inter vivos, during your life. So if you, for instance, we'll just take you, Martin, say you decided you wanted to create a trust. You during your life, you create this trust, you fund the trust. In other words, you put your home, your other assets in that trust. And that trust is a contract between you and your trustees, whether it be yourself as trustee or someone you designate later. And that contract says, at my death, do these things. And the law in Oklahoma says, because you've got that trust, then you don't have to go through probate. So as long as you have a trust and you put your assets legally in the trust, you totally avoid probate. Now, the only reason I took time to differentiate or to discuss the inter vivos or living part, you can create a trust in your will, which is called a testamentary trust. I really don't see a lot of advantage to that. There are some unique circumstances, but sometimes you'll see someone's will that says create a trust for someone at my death, and that creates a trust also. It's honestly, it's got all the negative sides of probate and the additional cost trust, so it's really not that great a tool, except in very special circumstances.
Are there simple things homeowners can do now to make things easier later?
Easier in the sense of avoiding probate?
Yeah.
Well, a trust, if you own a home, it's going to be subject to property at the death of the owners. Let me kind of, I guess, if the owners own it in joint tenancy, so you and your spouse, then it won't be subject to probate until the second death. But eventually it will be subject to probate. There are some alternates. You can do what's called a transfer of death deed. There's some risks with that. If the persons you intend to take the property don't act within 9 months, then they forfeit and it goes back into your state and causes a probate. So the simplest thing, honestly, is a trust. And doing a trust ensures it's going to happen. If you hire a qualified, competent estate planning attorney, they'll make sure your home gets in that trust as part of the estate planning process.
So you kind of touched on this with that last answer. Adding a family member to the deed, is that a good idea or bad idea? You kind of touch base that that's going to maybe extend probate a little longer, but it's still going to cause it to happen.
Martin, I think I may have confused you with that. A transfer on death deed, it sounds like you're putting someone's name on there. It only passes property at death. So it's in effect a will substitute. But to answer your question directly, I never advise anyone to put family members on their property for all kinds of reasons. If you have a homestead and you have homestead exemption, that exemption, it gives you some special benefits for property taxes, for creditor protection, various things like that. You can't own a homestead in joint tenancy with anyone other than your spouse. So if you add your children, your adult children's names on there, it destroys the homestead. It also opens you up to the potential for liability. Whoever's name is on that deed, if they get in trouble, don't pay their taxes, have a car wreck, and have liability, that creditor can come take the land. So I never advise that. And I know a lot of people do that as a way to try to avoid probate. They'll say, I just want to put my home in the name of my kids. And, I'm not saying that wouldn't work for some people, but I've literally had that happen 6 times in Cherokee County, where the single surviving parent did that, put the property in the name of their kids, and then the kids kick them out. So it's a bad thing.
Yeah, okay. I see how that could definitely cause some problems. When should someone talk to a probate attorney? Before something happens, or wait till after?
Well, a probate attorney has nothing to do until there's a decedent. I think a better answer might be, or a better question might be, when should you talk to an estate planning attorney? You should talk to an estate planning attorney, of course, during life. And that avoids the problems you'll face in probate with a good estate plan.
So this has really been eye-opening. Probate can feel overwhelming, but you've really made it a lot clearer for everyone. What's one piece of advice you'd give to someone dealing with probate for the first time?
We often see a lot of people with good intentions start giving out property prior to starting the probate. And without the court's authority to do so, you could be held liable for doing that. Get good legal advice. Do it the way the law provides. Make sure you're protected in what you do, and just follow the law. If mom or dad or family member wanted it to go a certain way, the law says they would have done a will or a trust. A lot of people confuse, mom's whispers in their ear or the video of what they wanted as something that will work. It won't work in Oklahoma. You've got to have a will. And if you don't have a will, it'll go the way the law says. So get competent legal advice and follow that competent legal advice in the probate.
And for someone thinking ahead, what's the first step you would recommend they take?
Well, again, if you're thinking ahead to a probate, I would assume that's only after someone has passed away. Gathering up information, what did the decedent own? Who were the family members? If the question geared more towards what you're thinking ahead about to avoid probate, it would be that you're trying to save your loved ones the headache of a probate. So that's the thought. Someone who's not dead, obviously, or who's not dealing with the death. You're planning for the eventuality of death. So let's make it simpler for those we leave behind and do a trust. So that's the 2 scenarios for advanced thought anyway.
Where can people reach out to you if they need help or have any questions?
Well, we have offices in Tahlequah, Muskogee, and Broken Arrow. We've got a website, gclawgroup.com, 918-456-6113. It'll get you to any office that way. We're always happy to help with either estate planning or probate.
Thanks again, Wayne. Thanks for joining me. You've been super helpful and informative today. If this sparked any questions for you or someone in your family, please reach out. A little planning goes a long ways. So make sure to like and subscribe and share this with someone who might need it. You never know what they're going through.
Thanks, Martin. Appreciate your time.
I appreciate yours.